The next matter to come before the court this morning is Michael Fraelich versus Donna Parrish. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you're the appellant and wish to reserve time for rebuttal this morning, let me know. I'm keeping the clock and I can keep you apprised of the passage of time. The court's read the briefs and we are ready to proceed when you are.
Your Honor, I'm Kenneth Fraelich. I represent the appellant. I'm presuming we're going first.
Yes. And if you would utilize this podium up here, counsel, thank you.
Your Honor, I do wish to utilize 5 minutes should it be necessary.
I'm sorry, I'm having some problems with all my cords and everything, so I apologize.
Computers are always the problem.
When they work, great. It's usually the user error, as they say. So it's user error on my part. I apologize.
Should I proceed?
Please, thank you.
My name is Kenneth Fraelich. I'm an attorney for the appellant Donna Parrish and the mother of the subject child in this particular case. We've assigned two assignments of error in this case. One of them is the failure on the part of the trial judge to initiate support or order support to commence from the time the child was born, rather from the date of the trial. The child was born in November of 2012, and support was not ordered to begin until roughly September of 2014, a period of about 16, 17 months. The basis for our assignment of error, number one, is that Ohio law states that the obligation of a father to support his child commences with the birth of the child. 311177 states that a man is presumed to be the natural father of a child pursuant to section 311103 assumes the parental duty of support with respect to the child. Further, the trial court must award child support from the date of the child's birth to the date of the paternity adjudication. The reason for this rule is that the legislator meant to deny support for the child between the date of birth and the date of adjudication. We could have said so. I think it's quite clear that the legislature, when it enacted this law, looked at the relative responsibility between parents. And I think it understands that there are parents who don't get along. There are parents who are conflicted. There are parents who have ill will toward one another. But none of that, I think, in the view of the legislature, was as important as the duty to support the child. It understands that divorcing parents, parents who are separated, may not want to get along, may not even want the other person to succeed or to have success in life, even sometimes to the extent it doesn't want the child to succeed. That's how some of these parents feel. But the overriding concern and desire for the legislature was to have that child be supported in a financial sense, because they know that it takes a lot of money to support a child. It takes two parents both contributing.
What discussion, if any, was had about the support of the child prior to the order? Was there an argument made on behalf of the child regarding the necessity for a support order? I understand the argument is there need not be that argument made, that the trial court might be required to make it, but was there anything before the trial court when it made its order about that time period?
There was information provided to the court about the parties' relative circumstances, about their income. There was also an inquiry directed to the father along the lines that had he contributed anything to the support for the child. And in the transcript, there indicates that there was virtually no financial contribution from the father for the child from the time the child was born.
How long was it before the child's paternity test was done?
I don't know exactly. It was a matter, I'm guessing, probably about a year.
There was some deliberate delay on that?
There was an allegation of deliberate delay on the part of the mother, absolutely. I did not represent the mother at the time, and I do know that there were some actions on her part that I thought were imprudent, absolutely. But I'll get to that in just a second. But once again, we'll talk about that. At any rate, I've cited in my brief a couple of cases. One of them is Ball versus Carter, 3-0 Act 3139, and ruled that a juvenile trial court had the authority to order father support obligation to commence at the date of the child's birth. The court also stated that the awarding of a monetary amount for child support is a matter generally within the discretion of the trial court, but this does not permit it to ignore the fact that under 311117, the child is entitled to and the father is obligated to provide support from the date of birth. Now, there was a reference in the appellee's brief to that case also, and what it stated basically was that, and again this is quoting from the Baugh case, states that in the absence of an affirmative demonstration of some circumstance which ought reasonably to relieve the father of his obligation and the child of this entitlement, that the court could, in its own discretion, perhaps not order child support or order a reduced amount of child support. What's critical in there is a circumstance which ought reasonably to relieve the father of his obligation and the child of this entitlement. Okay, mother's behavior was not perfect. She should have been much more forthcoming with not only the paternity test, but also with visitation and things like that. However, there's nothing in there to indicate the child did anything, whereas the child should be relieved of the entitlement to support. The child didn't do anything wrong. The child needs the support from his father. He needed it from the day he was born. He didn't get it. The court had a lot of other options it could have done to the mother had it wished to. If she didn't show up for a support hearing that she had filed through her previous attorney. I don't know why. The court had a lot of options there. They could have ordered sanctions. They could have held her in contempt. They could have done the same thing when she delayed the child support. They could have punished her for her lack of cooperation. But by withholding an order of child support for a period of almost 16 months, you don't just punish the mother, you punish the child. And I don't think the child did anything in this case that justified the father from excusing him from having to pay support. And if you want to look at that in a further circumstance, not only was he relieved from having to pay support per court order, the court was also aware of the fact that he didn't contribute anything to this child, not a bag of diapers, not any food, nothing for a period of 16 months. If the father had perhaps been making in-kind contribution, I can certainly see where it would be justified that the father wouldn't have to pay support back in that day. He did not. He elected not to do anything when it comes to the material benefit of this child for a period of 16 months. And then the court, rather than punish the mother, turned around and said, you don't have to pay support for that period of time either.
At what point in that 16 months did the paternity test, was the child's blood tested to prove paternity?
Your Honor, I don't know the exact answer to that question. I'm pretty certain it was roughly a year.
So even if there is a delay, you say that the statute requires, for the benefit of the child and social purposes, that it be retroactive to a time when the father may not have been certain that it was his child.
That is my reading of the statute. Because once he becomes aware that he's the child, that obligation under 311103 says the trial court must award child support from the date of the child's birth, okay, to the date of the paternity adjudication. So that period of time is covered, and I believe the language is mandatory. I think that, again, courts do have discretion in circumstances where the mother might have done certain things wrong. In this particular case, one of the arguments I'm making is that this is an abuse of discretion.
Can it be both mandatory and an abuse of discretion? I mean, it's mandatory, the trial court would have no discretion, correct?
Well, it says it's mandatory, but then when you read the language from the opinion of the Baugh case, there's that information. It says that in the absence of an affirmative demonstration of some circumstance which ought reasonably believe the father, apparently that case believes that there might be some level of discretion.
You're just now reaching your, I'm sorry, I'm ahead of the game. You're not, you have about 6 minutes remaining. I know you want to reserve 5. I'll
Yeah, okay, I'll get out of this. The other argument, other assignment of error is the reduction, 43% reduction in downward deviation. And our position is that the downward deviation is excessive. The fact that he has a child roughly 43% of the time might be grounded to give it some sort of downward deviation. But again, the standard visitation guidelines presume the child's going to be with the father approximately 27% of the time. So it's our position that it was an abuse of discretion to reduce it that much. The essence of the abuse of discretion argument, I think, in our particular case is particularly compelling when you look at the fact that the judge saw that my client was not cooperative with the paternity test, was not cooperative with visitation to some extent. But the court had a lot of other options. Apparently, it looked to me, when you read this entire thing, that the decision is unreasonable and arbitrary because the judge did not like what my client did and therefore turned around and, for lack of a better word, dropped the hammer on it. And my opinion is that the judge had a lot of other leeway, a lot of other things he could have done to do that to make up for her poor behavior, rather than punish her in this way and punish the child also by depriving the mother of the financial wherewithal, especially in a case where the father made no contribution to the raising of his child. The overwhelming financial burden that any child can create, especially on a person who's a school teacher. One-income household. My client bore all the responsibility financially for this child. My client provided the health care. My client provided the food, the shelter, everything. She got nothing from this guy. And because the judge apparently did not like the way that she conducted herself in the first 16 months of this child's life, none of which, by the way, was anything that negatively affected the child in an overt sense.
Also, you just over 3 minutes remaining. You proceed to reserve as you choose.
So, at any rate, Your Honor, that is the essence of our argument with regard to the two signs of error.
Lindsay Nichols on behalf of Appellee Michael Fraelich. I, unlike fellow counsel, did have the opportunity to be a part of this case from the moment of the inception of the original complaint for paternity. And I'm very aware of what was entailed in this whole entire process. The first assignment of error that he indicates with regard to the trial court not assigning support from the date of birth onward. He already has quoted the statute, the case law that I also had quoted as well. And there's nothing in my reading and understanding mandating in trial court to ever say that it has to be from date of birth onward. And in fact, it is abusive. It's a discretion of the court. So the standard that we're looking at today is whether the trial court abuses discretion in not assigning child support from the date of birth onward. The trial court did go on to clearly delineate as far as the reasoning behind his overall opinion in this matter. And part of the appellant's argument with Boggs versus Carver, I'd like to just firmly state that it says, in the absence of an affirmative demonstration of some circumstance which ought reasonably to relieve the father of his obligation to the child of his entitlement. I'm going to stress that what happened with the father is that he was actively, for 16 months, trying to not only meet his son for the first time, but provide support to this child. He attended all court hearings. He attended the hearing with regard to support, bringing all the information that he needed. The appellant failed to do any of that. She actively and willfully denied him both time, both meeting his son, and both his ability to actually give diapers, give information, give anything to this child, because she would not communicate, she would not appear for anything, she would not even communicate through her attorney.
Well, let me ask you a question. How do you distinguish this case from just a situation where mother never divulges the name of the father, and then father is sued for child support and has to pay for 18 years worth?
In that circumstance, I don't think there really is a distinguishable mark. I think there is a point, the court is a court of equity, and to have a father who never knew that he had a child and then having to pay 18 months, or 18 years even, that to me would be inequitable for a
But the
father.
courts have upheld that routinely, and we've upheld that routinely, because the whole point of child support is for the benefit of the child, it's not for the benefit of the parent.
Understood, and I think in this circumstance, though, my client had the ability to actually do so, and he was trying. It wasn't as though he wasn't aware of what was going on. He was the one who filed the complaint initially to establish paternity, and for 16 months, he was trying to not only, again, meet his son, but he was trying to do these things. And there was nothing, it was silence, it was radio silence on the other end. Wouldn't communicate as to what she needed, wouldn't communicate as to what, anything. There were several orders saying that she had to comply with the paternity test, she never did so. There was an order for a notice from Lorain Child Support Agency saying that she had to appear for a hearing. She never did, and that was August of 2013.
So I guess what I'm wondering though is that father's position that because mother, basically established all these roadblocks that he wasn't responsible for the support of his child for the first 60 months of his life.
It's not his position, it's the fact that he did try through counsel, through myself, where we would reach out and try to see what we can do.
I understand that. I'm just trying to figure out that legally he feels that he's absolved from liability because mother blocked his attempts to get paternity and to see his child. So therefore he didn't have any responsibility to financially support his child.
In some respects, yes, but what I'm saying is that he actually did try to make attempts to support his child, Your Honor. And when paternity was established and when he did go to the support hearing, and he was actually able to see his son for the first time, he brought diapers to the supervised visitation, he brought toys, he brought all of these things. There was a time when the diapers were too big because mom would fail to convey to anybody what size diapers the child needed.
Now, did he attempt to send any kind of money or payments or checks or anything to mother before that?
On the record, no, Your Honor. But again, and it's not a matter of the other part with this, and I keep saying the willful intentions of mom, and I understand that a child is entitled to support 100%. But it's just, in this present action, it was so willful and so utterly.
And it seems like it's contemptible.
Yes.
Not to take away from the child. That's what I'm trying to figure out how to, because absolutely you can't just not show up for court proceedings and just thumb your nose in the court, but isn't that why we have contempt?
And yes, Your Honor, and actually there was a show cause motion against mother, but nothing, it just kept being postponed and postponed and postponed. So I don't know procedurally the reason for that, as to why the court just kept postponing the show cause motion and why orders kept being added to say that mom had to comply and nothing happened. And that may be the trial court's reasoning for moving forward the way they did. I'm not sure.
Well, that goes directly to the question that I asked appellant's counsel. counsel. What's in the record about this period of time, other than the fact of the child lived with mom and she did not receive money? What's in the record with respect to any argument or finding by the court specifically as to whether or not the father should be relieved of this from the time of birth to the time of support?
As far as what the opinion was for the trial court at trial, I did not see anything delineating that reasoning, Your Honor.
I didn't either, so then are we stuck with a situation where it would be possible for mother to make a request for that period of time for child support later?
I would say in this situation, no, for the following reason. There was a court hearing scheduled specifically on the issue of support as of August 2013. Mother failed to comply with that notice. She failed to appear. The appellee did appear with all the information that he was subjected to when you are required to for the administrative hearing. He did appear. Because the failure of mom to appear, they dismissed that action. So at that time, to me, the administrator was saying that any arguments are hereby dismissed. You had the ability to argue your points. You failed to do so. Sorry. And I just feel that there was that ability to do so, and mom again failed to.
I guess I'm still troubled with that. You can't waive child support. So in essence, the court is saying, I'm going to waive it for you.
And I understand.
I'm just trying to get you to reconcile those for me.
How I would reconcile as far as the argument about going all the way back to birth is again that whenever somebody comes into court and fails to appear, their arguments are dismissed. You can't come back and try to reclaim those arguments because of your failure, your unwillingness to appear in the present action. And what I'm arguing is that's what mother did as of August 2013. From August 2013 on, there could be a question. Helen didn't file another motion until October of 2013, a month before the trial actually occurred, and that's when it was heard. And unfortunately, we did have to wait a year to get a final decision in all matters, and so that the issue of support was pending that as well. So there's a gray area there as to whether there's truly an argument that he shouldn't be paying for that time frame when she again filed a petition as of October 2013. But I feel that her willful failure to appear at a court hearing, our administrative hearing with regard to support as of August 2013, that to me demonstrates that she waived her right to try to obtain support prior to that point in time. And with regard to, unless there's any other questions with regard to that, Your Honors, I'd like to move forward with the second example of error with regard to the deviation. I think we all are very aware of the statutes and case law with regard to the deviation process and how a trial court does have its discretion to do so. The trial court did very clearly outline the factors and enumerated what he believed to be the reasoning for his deviation. He focused on the factors of 3119.23, factor D and factor G. Factor D discusses when the extended parenting time can be a part of deviating from the child support schedule and guidelines. And in this situation, it also goes into, say, extraordinary circumstances, and when you go under 3119.24, it defines extraordinary circumstances as, again, extended parenting time between the parent and child. In this situation, the trial court did say 43% of deviation. The actual child support or the actual parenting time order is a true 50-50 split. The appellee and appellant both have the child 50% of the time. So the deviation of 43% is actually less than what the trial court could have ordered at that point. The other factor with regard to factor G is the disparity in income. With the disparity in income, trial court found and no one objected that the appellee's income was actually less than $5,000. a year. Appellant's income is $41,000 a year. Trial court rightfully imputed income to appellee $16,000. With this, my client, or appellee, was actually imputed income, and the guidelines were based on not only less of a percentage than he would be able to argue against, but he also was given more income than he actually does earn. And again, no one objected as to his earnings. No one argued a point of imputation. It was done because the trial court, I believe, felt that that was fair and equitable. So to say that the trial court erred in that circumstance, saying that it was passion or a bias on the part of the trial court, I would say that's an error, just given the circumstance of, again, the percentage that it was applied is far less than what the appellee could have asked for, and also the upward imputation of income of the appellee of $11,000. So given that situation, it just was very clear that the deviation was applied in a very thorough manner, and the trial court did use all the evidence and the arguments put in place to come up with their conclusion. With that said, I just request that the Honorable Court deny, dismiss the request of the appellant and enter the trial court as an order of the final court. Any other questions? Thank you, Your Honor.
I would like to bring up a couple of things. Number one, immediately after I was hired by the mother, we did file a motion to establish child support on October 10th of 2013, and that order requested that the father be directed to share in the child's uncovered birthing expenses and pass care retroactive to the date of birth, 11/16/12.
So are you saying that it was pending at the time that the court's order that's being appealed came down, but it was not addressed?
Yes. Yes, it was pending. It was not ruled upon either at trial or in the judgment entry. So that order was never, or that motion was never addressed by the judge. There's nothing in the record to indicate that it was considered in any way, shape, or form. And with regard to...
So are you suggesting it's not a final bill order?
No, I'm suggesting that it's an abuse of discretion that the court should have addressed that motion in one way, shape, or form when it came out with its orders.
But if it was pending, if you had filed that motion, there's still things before the court. That's what I'm wondering. That's okay.
I honestly don't know. I mean,
that's fine.
The motion was out there. The judge didn't say yes, he didn't say no, but he did rule on all the other issues.
That was not in your complaint, though.
Yeah, but the court had inquired as to whether or not there was something out there, and there was a request that was filed immediately after I was hired. And there has been some discussion of what the father did do in terms of trying to establish contact with the child, trying to move along the process of my client taking the paternity test and everything like that. What is without any doubt, though, is he did not contribute anything in financial sense in that 16-month period. And I think that our legislature and the courts have uniformly enforced orders with regard to visitation and orders to support as separate issues. That the courts do not take as a valid excuse the fact that you didn't see your kid as a reason not to pay child support. They are separate issues and they're treated separately for a good reason. And for that particular reason, I think that this court, in choosing to relieve the father of his obligation for that 16-month period and possibly take into account as a justification the fact that he didn't get to see his child as much as he wanted to, I think that's an abuse of discretion also.
Counsel, you have reached the end of your allotted time today. Thank you.
Thank you.
Thank you both for your presentations this morning. The court will take the matter under advisement to issue a written decision which will be mailed to both sides as well as posted on our website and the Ohio Supreme Court website. We are adjourned until Thursday. Thank you.